true confession, I'm from Naugatuck, so we had a situation, we had, born and raised, we had a, I don't live there anymore though, so don't, you get sorry. But a situation where there was this, it had something to do with a prank gone bad, with stolen swimsuit warm-ups. And so they're bringing the kids in to expel them or whatever. Well, yeah, they're all wearing their letter jackets. I mean, you know, it's not, sometimes you just can't help it, but, so you just want to, you be cautious as you can, and then let it fly. You're not in violation of anything if they get caught on camera coming in and out of the room or attending the meeting, so.
Okay, so the parents couldn't sue
No.
or identify?
No, because you didn't do it. You didn't do it in public. You didn't name them. You didn't. There's just nothing you can do. You went into executive session, I suspect, to a student disciplinary matter, which is perfectly legitimate. You don't name the kid. I mean, there's just nothing you can do. Remember that this law does not guarantee anybody the right to speak at a public meeting. I don't know if that's, you know, how that goes around here. A lot of people think that it does. A lot of people will call me and say, hey, I didn't get to talk last night, or you know, they cut me off or something like that. Well, there may be other issues. There may be political issues there. There may be, you know, you may have something in your charter or your bylaws that guarantee that, but not the FOI Act. The FOI Act only gives people the right to attend and observe a meeting, not the right to speak and participate. You may have a situation where you want to limit time. Again, I hearken back to budget season. We had a strict time limit, 3 minutes, period. My announcement at the beginning of the meeting was, we're not being rude here, but we got a lot to do tonight, and a lot of people want to be heard. We've got a 3-minute limit. I had, you know, the person with the stopwatch, and when the 3 minutes were up, he pointed to me, I cut the person off. Some people weren't happy, but you absolutely have a right to do that. Okay? There are 2 paths that boards can go down to exclude the public. There are some things that you're obviously allowed to do in private. You know, we started down there when we talked about the cameras. One is executive session. You've all heard of executive session. Remember that an executive session is a portion of a publicly noticed open meeting. So even if the only item you have is an executive session item, you still must notice the meeting, you still must convene it in public, and then take the vote to go into executive session. An expulsion hearing is a great example of that. Usually that was the only item we had. So it would say, Board of Education special meeting, time, date, place, agenda, executive session likely, consideration of a student disciplinary matter. So it was clear what was going to happen. And then, but you still have to vote, take a motion to go in for the expulsion hearing. You have your discussion behind closed doors. Remember, you can talk about anything as long as you want, but then you come out of that executive session to vote, which again goes to the problem you were talking about, but you must take that action in public. There are 5 reasons for executive session. You want to be really specific when you go in. A personnel matter, pending claims or pending litigation, a security matter, the sale or lease or purchase of property by you, if talking about it in public is going to negatively impact the deal. And the 5th one is something of a catch-all. It allows a board or commission to go into executive session to talk about the content of a document or documents that it believes are exempt from disclosure. And that, frankly, is where the student expulsion hearings come in. You're talking about student records which are exempt from disclosure. You would need to have those conversations behind closed doors. Remember that you need to vote. You need to cite the reason, especially in the motion and in the minutes, and you have to have a 2/3 vote of those of you who are present to take the matter into executive session. Some other examples of document, you know, do you folks deal with bids and RFPs at all? Or at least your transportation committee probably does. Remember that there is an exemption that says that you are allowed to withhold bids and RFPs from the public until you've concluded the negotiation or until you've signed a contract. It's a temporal exemption, so you know, you collect the bids and you're looking at the different bids for the bus contract, let's say, and you're looking at them and you're saying, well, gee, this one's better here, but this one's charging us more for, I don't know, what was it, returning to the shed. We always used to get hung up on that. Less mileage in town, but they charge us a lot to bring the bus. So anyway, you look at all that stuff. But you can have that discussion behind closed doors, because those documents are exempt until you sign the contract. Student records is another good example. You ask your attorney for a written legal opinion on a matter, and it's covered by the attorney-client privilege. You're not going to share it with anybody else. You go into executive session to talk about the content of the attorney's advice. That's the advice that the attorney has given you. Those are just a couple of examples. Yeah.
I have a question, because we're here tonight because of a decision that I made, and I take full responsibility
Yeah.
for that decision. But what happens in the case of this particular issue was a grievance issue?
Right.
Now, the board, to remain impartial, has no information on the grievance prior to going into that grievance hearing.
Yep.
In this specific case, for the reason that we're here, one of the items that we were told was going to be discussed was an individual employee's medical records.
Okay.
Now, as much as I feel we have an obligation to protect the students here, I also feel we have an obligation to protect the staff
Agreed.
here. So a decision was made to go into executive session because obviously I didn't feel, as the chair, that we should be talking about someone's individual specific medical records in open session.
There's the Supreme Court ruling from 1997 that said that the evidentiary portion of grievance hearings must be held in public. It's pretty plain. Now, they did sort of go Solomon on us and split it, and they said that once you've gathered all your evidence, you can then go into executive session to talk about your strategy as how to deal with that grievance. But the evidentiary portion of grievance hearings must be held in public. So the grievance, I'm sensitive to what the issue might be. Was about someone perhaps saying that he or she was being discriminated against because they had a medical condition, something like that?
It was an issue of seniority and medical leave.
Okay, so you could have the conversation. You'd probably have to be sort of dance around it a little bit perhaps, but you'd have the conversation about what the grieved issue was without talking about the specific medical condition. That's how you would have to handle it. There is an exemption for, we'll talk about that in a little bit about medical records, so you'd want to be sensitive to that. But let's take it out of the Board of Ed realm and say it was a situation with a firefighter. And the grievance was about being told to get back to work, and he's saying he's got a bad back. Well, you don't get in the chapter and verse as to how bad the back is, but you identify the issue as the bad back issue, and then you have the discussion gathering, chief thought he shouldn't go back to work, but the assistant chief did, whatever it was, you gather all your evidence, and then you go in and talk about the nitty-gritty behind closed doors.
How do you get the evidence when it's pertaining to the medical aspect of
Well,
the level of
again,
disability?
I don't know the details, but you'd have to try to find a way. And when you reach the point where you believe that maybe you can't get all the evidence that you need, and then maybe the executive session discussion, you actually look at the records. Let them lay out their basic case, and then you go in to talk about something that you believe is exempt. But you have to gather your evidence in public. The Supreme Court told us that. Tricky situation. That's the second one you've thrown out that's tricky about
It
it.
just seems to me that in that situation, you're gonna prevent people from filing grievances that may have a valid claim
Right.
because they don't wanna sit here and have all the medical information
very
on the front
good
page of the newspaper.
One of the things that those of us who work in the public sector have to live with is sometimes some stuff that you don't want, comes out. And that's one of the things you give up. You give up some of your privacy when you work in the public sector. Obviously, you'd want to be tactful when you had that discussion. You're obviously in tune with it, and I commend you for not just sort of barging ahead. But in a grievance situation, that's not us. That's the court. I mean, the Supreme Court said you got to do it. So the personnel executive session. To get back to that for a second, remember that if you have such a situation, you want to make sure that you've identified the individual that you're going to talk about and told him or her beforehand that you're going to do that. You want to make sure that your motion and your agenda, if you're going to put it on the agenda, doesn't say executive session personnel. again, the court has told us that they want more than that. Executive session, likely discussion of a, school district employee, of a school district coach, something like that. You don't have to name the individual, the courts have also told us that, but you want to make sure that you've given more than just personnel. You want to have more than just personnel. Now, if you're going to go into executive session to talk about the performance of the superintendent, there's only one of them. So, so the name, whether you put it out there or not, everybody knows who it is. But executive session, likely discussion of the performance of a teacher, discussion of, so you can, as put enough out there so it's more than personnel, but you've got to have a comfort level with what you put out there, yeah.
But does the evidentiary portion of the discussion?
We're beyond grievance. I'm talking about, let's suppose you're going to talk about for something else. You're talking about, this isn't a grievance. Now, let's suppose it's a disciplinary matter, and there's no grievance involved. Then the whole thing could be an executive session.
Oh, okay.
We were just talking about the grievance hearing that brought us here. And by the way, I think I said this before you came, that the point is not to come and beat you up about that. You asked the question, so I answered it, but these are things that you made a decision based on what you thought was the right thing to do. It just, in this case, wasn't the right interpretation, that's all. But what you're talking about, if you're going to talk about the performance of an individual, let's suppose it's a non-renewal situation, and the teacher challenges it. I don't know if those are lovely too, but you go into executive session, and that's because you're talking about the performance of the teacher. So that whole thing is an executive session. It hasn't been grieved. Now, if the teacher then turns around and grieves, I don't know what the sequence was, but let's say there's no grievance involved. Then that whole thing could be an executive session.
Unless the teacher.
Unless the person requests that it be done public. Remember, that's why you notify the individual. If the person says, no executive session, I want it done publicly, you don't go into executive session. Now, what sometimes happens is the person says, I want it talked about in public. And you say, I'm not sure that's the best idea, because you know what you're going to talk about. You know what the claim was or the charge was. You go to the person and say, look, you don't really want to do that. What if we invite you into our room to talk about it? What if we ask you to give us evidence, to give us testimony? That's certainly okay, because you can invite in whoever you want to an executive session to give evidence, to give testimony. Make sure that your minutes reflect it, that they were in the room. But you invite people in to talk, and then when they're done giving you the information they're going to give you, then they should leave the room so that you can deliberate.
Now, is there any notice requirement that we would need to adhere to of notifying the employees?
It's funny. It says you have to, but it doesn't give a time frame. I always say the best thing is to do at least 24 hours. Now, sometimes, let's suppose you're sitting in a room and there's something on the agenda that turns into a personnel matter, and it's not executive session, and the person's sitting right there. Would you mind going into executive session to talk about that? And if the person waives it on the spot, that could be enough notice too. But I think 24 hours is safe. I think that's the best way to do it. Okay? Did you have another question? Yeah.
Yeah, my question is, we have the right to go into executive session, but we're not mandated.
Never mandated.
To ever go into
Never.
executive
No.
session on anything that we do.
That's correct.
So there's not an issue that could possibly ever affect this board, that if the board wanted it to be done in open session, the board can do it.
Again, there's some debate over FERPA, over whether FERPA is an absolute rock-solid mandate or not. From where I sit in my former role, I always viewed it as such. I would err on the side of caution with an expulsion hearing and say that's probably best done to protect your rights under FERPA, protect the student rights. But there are some who argue that even FERPA isn't an absolute. I shy away from that. That's my 10 years on the Board of Ed talkings. But
Has that been litigated?
It's never really been litigated, no. I always viewed it as an absolute. There's some who, and there's not a large number of people, but there's some who argue that you could make a case that even FERPA isn't an absolute. I happen to think that it is, but.
What's FERPA?
The Family Educational Right to Privacy Act.
Thank you.
Or is it federal or family? One of those. Anyway, what it basically says is that records pertaining to students, educational records that identify students should not be released. Which makes it very hard when people make records requests of boards of education and superintendents, because most of the records are about kids. So The executive session for pending claims and pending litigation is pretty much what it sounds like. You've got a lawsuit on your hands. That, the aforementioned grievance, you've gathered your evidence, you're now gonna decide what to do about it, that's a pending claim. You could have all your strategy discussions behind closed doors. Pending claims, it's also a little broader in that it allows you to go into executive session to talk about taking legal action. Let's suppose for some reason you are going to sue somebody. Hypothetically, you're building a new school and the contractor's doing a horrible job and you want to pull his bond. You could do that. Have that discussion behind closed doors because you don't want to tip them off that you're about to do that. The security executive session, I must say, makes me very sad to have to talk about it. In the first 12 years of my job at FOI, I never talked about it once, maybe twice. But why has it come up a lot more lately? Sandy Hook, especially with boards of education. You can go into executive session to talk about expanded security details, where they're going to be, when they're going to be placed, bulletproof glass, things like that. It allows a lot of discussion. So the idea would be to not let the bad guys know what you're going to do to keep your kids safer. It's really sad. It makes me very sad to have to say it, but it's a reality. So
that'd be like the safety and security plan of the district.
Right. You could have that discussion behind closed. Now, there's a lot of debate about that. Again, not necessarily part of FOI. We want the community and the parents to know, what this, but there are parts of it that you don't want them to know. So clearly you could, but like evacuation routes and things like that, you may want to share those with. That's not my place to say. Some want to, some don't.
We recommended not.
Yeah, some do, some don't. But you have a right to withhold because, and to put them together and talk about them. Now, again, you're going to vote on something like that. You're going to vote on an expulsion. Yes, you have to vote in public, but that doesn't mean you have to give away the store. Mr. Chairman, I make a motion that we approve the security plan that we discussed behind closed doors, and that's all you need to do. Okay. And the property thing we talked about and the records we talked about. Remember, folks, just don't take action behind closed doors. You want to make sure that your action is public and recorded. That's a really important piece. Yeah.
Say if we had a safe location where students were transported to, does that kind of information have to be released to the general parent body?
Again, we haven't talked about, we'll assume that's a records request. There is a piece of, of the exemptions that said that if you believe it's a security risk to release the document, then you don't release it. There are steps you take to make sure that others believe that it's not. Municipal agencies have to talk to the Department of Public Safety. Well, and they say, look, we've got the request for this record. We don't think we should give it out. If they agree with you, then technically they're supposed to help you defend the decisions with somebody. So many of the record exemptions are interpretive. If you believe it's a safety risk to release it, then you stand by the exemption and don't release it until somebody tells you you have to. Yeah, sure. Now, two paths we talked about excluding the public. One's the executive session. The other one, has anybody heard the term non-meeting? Has anybody heard that term batted around? It's enough to make me put my head through the wall. If you think about it, it goes like this. The definition of a meeting, the next sentence reads, meeting does not include. The very next sentence, so they define meetings, they tell you everything's open, and then it says meeting does not include. There follows a list of gatherings, for lack of a better word, almost every which one we would call a meeting. We absolutely would. All of us sitting here at the table. But the legislature said you can call them whatever you want. For the purposes of FOI, they're not a meeting. At the top of the list, especially for you folks, is collective bargaining. Your collective bargaining sessions, your negotiating sessions, strategy sessions are not covered under the meetings provisions for FOI. Who's on the bargaining committee?
We all are.
You all are? Isn't that so much fun? Mm-hmm. You sit at a table for hours. You exchange proposals. You give them one, they laugh at you. They leave the room, they come back with a counter, you laugh at them. But you're here all night, going back and forth, percentages, insurance, da-da-da. Is that not a meeting? What else would you call that? But for the purposes of freedom of information, the law says that's not a meeting. Hence the non-meeting. But by the way, when you go home from your next negotiating session, don't try telling your spouse that you've spent 4 hours at a non-meeting. It don't fly, because nobody knows what it means, but it's not a meeting. So not noticed, not open, no minutes. The superintendent finishes the illustrious career and moves on, retires, goes to Florida. You need a new superintendent. Executive level search committees meet in the non-meeting mode. That one actually makes some sense to me, because you've got a situation where you're looking for the best and the brightest, and you're probably going to get applications from people who have jobs and don't want their current employers to know it. So, but you could do that work behind closed doors, not noticed, not open. But if you've ever been on one of those search committees, that takes hours too. And what else is it?
In fact, when I was on the DD council, we had a situation because of what we called it. It turned out that we were in violation
That's right.
of
Because
FOI.
you didn't take that step.
Right.
Yeah, they had a bunch of people gathering, and then said, we're not gonna tell anybody about it, forgot to name it as an executive level
Right.
search committee.
And we got in a lot of trouble.
Well, they also had a few difficult people that they were dealing with.
Yes.
Social yeah,
Impact bargaining, same.
what's that?
Impact bargaining is the same.
Collective bargaining, but yeah,
On the collective bargaining,
Yeah.
that's the right of the board versus the right of the bargaining groups.
well, the bargaining
groups want it in open session.
no,
Board-
the board's under no obligation to do that. The board's under no obligation to do that.
Board wants it in open session.
Well, I guess you
The
could,
bargaining group says, no, we wanna be in executive.
I guess you could, I've never seen it, but I guess you could, because it falls under the things that are not a meeting, but if you wanna put on your agenda, we're gonna negotiate this contract in public, I guess you could do that.
And the whatever
No,
bargaining
the
group
board-
has no right.
I mean, they might not show up, but yeah, I don't see, now, there may be collective bargaining laws that might come into play, but none that I know of.
But would that be bargaining in good faith if you're requiring them?
Yeah,
to
I mean,
do it?
usually when you sit down to bargain a contract, the first thing you do is you set ground rules. And one of the first things you do is you say, these are all gonna be behind closed doors, sort of a, what do they call it, a blackout, you don't talk to anybody about any of the terms or anything like that, that's usually one of the first things you do. So what you describe, I can't ever see it happening.
Even though it's the public contract.
Yeah, it doesn't matter.
It doesn't matter that the
no.
public doesn't know what's.
Collective bargaining, yeah, that's right, yeah.
It'll become public soon enough.
Yeah, it sure will be, it sure will be. Some of the other things in that category, I asked this not knowing the answer. Is this are you a political group? Do the Rs and the Ds, go into separate corners, or you try to be nonpartisan? Well, if you were, there's a provision in this law that allows for a caucus. It allows members of the same board and the same party to caucus. Now, this one's kind of interesting. I think that this is one of the areas where there was tremendous dispute when they put this law together. And people actually objected, and they said, well, wait a minute. If you've got a 9-member board and 5 of them are the same party and they go off and caucus, aren't they going to be in control? Can't they decide anything they want and go forward? Well, obviously the answer is yes. But they were sort of pushed aside and said, no, that's not what the caucus is for. That's to decide who brings the donuts to headquarters on Saturday mornings and where the street signs are going to go. And they sort of tamped down on the debate, when in fact that's exactly what's happened. And there's some places where the caucus sets the agenda and the minority party kind of gets shoved aside. We don't love it. If you like open government, you probably shouldn't love it. But where a lot of people get into trouble is they say, let's have the superintendent come into our caucus. And once that happens, it's not a caucus anymore. Remember, it's same board, same party. Same board, same party if you're gonna do that. And the town chairman wants to come and talk to, don't do it. Same board, same party, you're allowed to do it. The other thing that's on there I get a chuckle out of is social gatherings. And the wording says, social meeting neither planned nor intended for the purpose of discussing matters relating to official business. Well, what the hell else are you guys gonna talk about? I mean, that's what you have in common. So look, again, let's not be naive. You go out to dinner. You're gonna have discussions. Stay away from the deliberative conversations. Make it just, if you're gonna exchange, somebody misses a meeting. what did I miss? That's okay. Or you wanna make a point, say, look, this is what I think we ought to do with this. You write it down, you pass it out to everybody, but then don't start passing around opinions. Don't start saying, okay, this is a dumb idea, or this is a great idea. This is what I think, and then just leave it at that. That pertains more to things that are in writing. The conversations at these social gatherings, just try to keep them light. Try not to go into a situation where you're gonna be talking about board business, that, you know, Bruno's sitting at the next table and he hears it all and he files a complaint. Because that's what people say, well, what's gonna happen? That's what happens. You say, no one's gonna know, and that's what happens. So you wanna avoid the.
Have time to socialize.
Yeah. We didn't, but you must have a Christmas party, right? Don't set the budget, you don't? Oh, wow. Have a Christmas party. You have a Christmas, don't.
Yeah, it's not in the budget.
Yeah, don't set the budget over the eggnog next year, okay? Just be careful. Now, in line with that, these casual conversations and stuff, dial back to the beginning of the conversation. Meeting happens whether in person or by means of electronic equipment. Electronic equipment was written 39 years ago for that powerful board chair who got on the phone and said, okay, you're doing this, I need your vote that, you need boom, boom, boom. You walk into a full house, place is packed, waiting for a big debate, all in favor, all opposed, and everybody's looking around, what happened? What happened is they had the meeting on the phone before the meeting took place, and you cannot do that. You cannot do that. And in 2014, we're talking about a lot more than telephones, aren't we?
Oh, yeah.
Emails, text, and Twitter, and Facebook, and all these things. I'm not telling you not to use those vehicles to disseminate information. That's a better example of what I was talking about with, you know, what you were saying with, what I was saying about, you have a position, you want to give to everybody. You email it to everybody. That's fine. The problem comes when people start coming back at you and you're having the conversation. Don't stop using these vehicles to get information out, or to find out when the next meeting's gonna be, or to say, hey, I missed that at the last meeting, what happened? You can do that, but don't have the conversations via any of those things that you should be having here at the table. You can't stress that enough. And you know, you've gotta be careful where the line is.
And that includes starting a new email. If you got a question from the chair or a statement from the chair and then you don't respond to that, you start a new email to respond to it. There's
Yeah,
still links.
the response is the problem, yeah. And remember that these emails become public records and you know, you're just asking for trouble. If it's your statement on something, you say, okay, kids, here's what I think about this, we're gonna talk about it at the next meeting, perfectly fine. But it's when the conversation happens behind closed doors that you're in trouble, yeah.
Is there a time limit for archiving electronic communications?
Fortunately, I can't answer that question. There is a records retention law in the state of Connecticut that tells you how long to save, how long to hold any kinds of records. So you want to make sure that you know what those laws are. Now, I don't know, does the administration have those that you can share with them about the records retention laws or anything like
I
that?
only have school records.
Okay. Somebody might want to check with the records retention as to how long to save some of those documents. They have different categories for emails. One of them is transitory, you know, the email that send out the conversation about when to have the next curriculum committee meeting. That's probably transitory, it can probably be deleted at will, but if it's something more substantive, they'll probably tell you to save it longer. Remember, when we talk about emails, and we'll talk about records in a second, it doesn't matter what device you're using. People say, well, I'm using my personal device, it doesn't matter. If you create something that has to do with your school board work, on that, it becomes a public record. It doesn't mean I get to take it and look through everything that's on there. It means that if I asked for them, you'd have to produce whatever you have on there that's related to school board business. Okay? The last thing we should talk about with meetings, before we do a little bit about the records provisions, is minutes. Is the minutes taker in the room? Oh, man.
I'm one of them.
Okay.
I'm one of them.
You know, because we do, as administrators, we do the minutes for the subcommittees, although that.
Remember that minutes need not be the recreation of War and Peace. They are not every word that everybody says. When you have some of these, especially some of these long budget meetings, people will look at the minutes the next day and say, hey, wait a minute, I had all this to say and it's not in there. Not required. The only technical requirement for minutes is a record of who votes for what or for whom, believe it or not. That's the only technical requirement for minutes. So you want to make sure that you have that in there, and then you wanna make sure that you've created something that, for lack of a better phrase, creates the historical record. You want more, but it's your call, it's on your terms what's in there. You know, you wanna recreate the flavor of the discussion, you wanna put in something that says, you know, this is what happened, so that somebody picks it up a year from now, 5 years from now, they have a sense of what the board was thinking.
But that's fine, but I mean, as far as FOI is concerned, as long as we have the votes, who voted for what, and the agenda items, the matter was discussed, so-and-so
all
made
you
the
need.
motion, seconded, unanimous.
Absolutely all you need.
I mean, pretty much that's it, as far as FOI
Right.
goes.
And the unanimous part, just a little tip, you probably already do this, when
Yeah.
I do the FOI commission meeting minutes, so
Yep.
I feel your pain, by the
Yep.
way. At the top of the minutes, I say, okay, meeting, official meeting, boom.
Right.
Board members A, B, C, and D were present, so if
Right.
it says unanimous, I don't have to list them every single
Right,
time.
yeah, because we do the same,
Yeah.
members, and then
Yeah.
if there's anyone else,
Right,
okay.
right, okay? Remember that the minutes need to be available within 7 days. A lot of people say, well, wait a minute, 7 days, we don't vote again in 7 days, they're not approved. If you're uncomfortable having them ready in 7 days, make sure you put on, you can put something on there like, subject to approval, or yet to be approved at the next meeting, or something.
Something draft
Draft, you
watermark.
can put that on there if you want to. Not required, but if your comfort level is better with that.
And when you say made available, where or how?
Well, that goes to the question that you asked before.
Go to every house and talk.
They would have to be available
And
here.
delivered
Yeah,
to every house.
they would have to be available here in your office. That's the only place
Okay.
they're required.
All right, so I mean, I don't have to post the draft
No.
minutes on the website.
No. Again, that
So as
goes
long-
back to what we talked about before as well.
Okay.
Now, there's another little wrinkle there that says that there has to be a record of votes available within 48 hours. But that's pretty simple because you know what they are. They come into the office, someone wants, there's no requirement for a formal document there, just that the record of the votes be available in 48 hours. Okay, I think that's everything I wanted to share about meetings. Are there any questions before we talk a little bit about records? Yes, sir.
A good example, a good example. Board member says, I heard that teacher or administrator did X, Y, Z bad things
Okay.
at the meeting. But we're not gonna take any vote, nothing like that. Doesn't have to be in the doesn't have to be in the minutes. I'm gonna make an allegation of this thing that took place on January 1st, of bad things that took place. But because there was no vote on it, it doesn't have to be in the meeting.
Doesn't
in the minutes.
necessarily have to be, no. Now, it would be somewhat disingenuous if a long discussion ensued about this, if there, but technically, no, it wouldn't have to be in the minutes. What else? Yes?
Your thoughts on someone making a undeterminable, whether it's founded or not, allegation in a
Okay.
public meeting against
Um,
a staff member?
This is me speaking.
Yeah.
It's not necessarily part of FOI. I'm putting on my former board chair hat. I would find it reprehensible, to be honest with you. I would think that that's something that should be done perhaps in writing, and discussed. If you feel seriously that there's a problem, the executive session route is what I would recommend. I would recommend going into executive session to have that discussion, informing the person. Now, if the person wants it done publicly, the problem is that you never know how bad, we all have parents whispering, I don't anymore, thank God, parents whispering in our ears. Did you hear this? Did you know that? Well, you don't know what the bias involved is. You don't know what the situation is. So you take that information, and if you can't couch it in terms that wouldn't identify the individual, my recommendation would be to say to the chairman, we need to have an executive session to talk about something I heard, and then go through the process of notifying the individual. That's how I would handle that. I suspect Cabe and Caps and all those people would tell you the same thing. Yeah.
For security purposes, buildings are frequently, or customarily locked after school hours. Sometimes there are meetings going on in that building.
Excellent question. You need to make sure that the public can get in. If you're more comfortable locking the building, then you would probably have to have a person out at the door. or a security buzzer to let people in. You don't wanna set it up so that people can't get into your meetings. This, until Sandy Hook, until 9/11, a lot of police commissions met in the police department, and those buildings were locked. And they were repeatedly told their decisions, again, commission and court decisions that say, don't do it. Because if you've barred people from meeting, you've violated the law. So you'd have to work something out. I'm not saying that the building wouldn't be locked, but you wanted to make sure that every last person who wanted to get in could get in. And that, you'd have to sort of figure that one out on your own. I don't know your buildings or your staffing, you know, maybe the custodian needs to sit by the door, I don't know.
Well, that's common sense, except we don't always do it.
Yeah. And if it's that one time that you don't do it, someone files a complaint and said they were meeting inside and I couldn't get in, you'd be wrong. Yep. Okay. I'm looking at the clock, we spent a lot of time on meetings, but that's good because you're the Board of Education. But that means I'm gonna condense the records portion really, really quickly, because, you know, I promised you 90 minutes and I don't wanna go beyond that. You all spend enough time at night away from your families, I get it. But when I go through this records portion, I may not hit something that you wanna ask about, so either ask while we're going through it, or I'll stay afterwards and we can answer the question. It's not a problem. When we talk about records, the first thing, the main thing that you have to remember is that any record you create in the conduct of the public's business is defined as a public record. I'm going to read you two parts of the definition. Public records or files means any recorded data or information relating to the conduct of the public's business, prepared, owned, used, received, or retained by a public agency, or to which a public agency is entitled to receive a copy by law or contract, whether such data or information be handwritten, typed, tape recorded, printed, photostated, photographed, or recorded by any other method. That's
Stop
part
right there
one.
for a sec, so
Yep.
this means us writing tonight is public record?
It's defined as a public record, but as you'll see, there's an exemption for personal notes. So if someone says, I want to see the superintendent's notes from the FOI meeting, you could say, it falls under 1-210B2, B1, and I'm not going to give them out. Unless they somehow become part of a larger manifesto that you create, and it becomes the building block for part of a file or something like that, but for the most part, your personal notes are not subject to FOI. That's not subject to release under FOI, is what I meant to say. Except as otherwise provided by any federal law or state statute, all records maintained or kept on file by any public agency, whether or not such records are required by any law or by any rule or regulation, shall be public records. And every person shall have the right to inspect such records promptly during regular office or business hours, copy such records in accordance with, it gives you the section number, or receive a copy of such records.
Is a application a public record?
Yes, it is. Yes, it is. Everything is a public record. So, when somebody comes in and wants to see it, again, all too often, we get, go ahead, sorry.
Oh, I was just gonna piggyback on Cheryl's, an application after the job's been filled, or
At any
even.
time.
Okay, so
At any
even if
time.
somebody's applied and we haven't
Didn't get the
voted
job,
to his,
right.
we haven't voted on who's gonna get the job yet.
Except if it's an executive level position. That whole executive level search thing, those are never released unless the candidate gives the okay. Those applications, those resumes. That's part of that executive level search thing that we talked
But a
about.
teacher,
So what would so give me an example of executive level. I mean, obviously the superintendent, that's it, or?
Well, that's a very good question, because my district has one high school,
Yep.
one principal. He was basically number 4 or now, you know, in the district. So, in our district, that was an executive level position, and we interviewed as such. New Haven has, you know, multiple high schools, so it kind of depends.
Okay.
There's a case where an individual who is a, shall we say, difficult individual over in Windsor tried to say that the school principal was not an executive level, and we ruled that it's interpretive. It's up to, but if the district believes it's interpretive, then it's executive level, and he took us to court, and the court overruled him and said, no, that's ridiculous. The district has placed a lot of responsibility in this person's job description, has given him oversight over significant number of people in the district, and I mean, those are the kinds of things. So you make the call on that, basically. I mean, some things are obvious, some may not be as obvious.
So it would be safe to say that if the district were to identify an executive level position in a policy or something, if there was a list that was a public record that said, we consider from these 12 positions executive, everything else is not. That would clear.
That would, yeah, I mean, that would leave little doubt. That's not a bad thought, yeah.
Even if they were in bargaining units?
It doesn't matter. If it's an executive level position, that's your call. Most in those positions are not, but on the other hand, that high school principal I just referred to, he's in our administrator's bargaining unit, so yeah. It's clearly, in my district, it's clearly an executive level position, and he's in the bargaining unit, so it doesn't matter. It doesn't matter. If you identify the position that way, that's how you deal with it. So people tend to get possessive, tend to get selective. Oh, he's back again, we don't want to deal with him. You're a nice guy, you can have him, but you look like a real pain in the neck, so we're not going to give him to you. I want to encourage you. I want to encourage you. Did I hit it on the head, huh?
Yeah.
I want you to think in terms of everybody the same way, even the difficult people. You don't want to get selective. You don't want to get protective. You want to understand that it's a public record, and then apply what we call the 3 E's: the exemptions, the exclusions, the exceptions. Think in terms of everything as a public record, then apply those, and try to put blinders on when it comes to who's making the request. All too often, agencies get into trouble because they try to dance around who's making the request. So I'm going to share with you a story, perhaps to add a little levity to the situation. I used to make up a story of what not to do when somebody asks for a record, what not to do. And a few years ago, God bless them, the city of Hartford gave me a real life example. Now, we're recorded, so I'm going to have to clean it up a little bit, but you'll get the idea. The person making the request was a quasi-journalist. He does a blog, he does a public access TV, but he's around a lot. He's making a lot of requests. And in this particular instance, which leads to them not liking to see him coming. They just don't want to deal with him. In this particular instance, he asked for 2 things. He asked for a record of bills submitted by a law firm doing some private work for the district, and a record of payment from the district to the law firm. So the corporation counsel for the city of Hartford responds, I have your FOI request and will coordinate the response. Such documentation as is allowed or required by law will be provided. Now folks, the law says that within 4 business days you respond to every request for records. But response really means acknowledge. It doesn't mean you have to scramble to get the records in 4 days. In 4 days, you respond. So if this was okay, I would also recommend putting in some sort of a time frame when you think, when you think the records will be available, so that the person's not, running in circles or calling every 5 minutes, all those things. So what's the problem? The problem is that in the process of responding to this individual, whom he does not like, whom he cannot stand, really, he accidentally copies the individual on an email he had sent to a colleague about how much he didn't like the guy.
Oh, jeez.
Everything is defined as a public record. Now, this is one that may never have seen the light of day if the attorney hadn't hit the wrong button. But it's now out. So, by the way, as an aside, think before you write, and certainly think before you send. We have a tendency to communicate today via email, and those of us in the public eye have to realize that we're creating public records. But he wasn't thinking.
Send is not your friend.
Right. We have a colleague in Virginia who stands up before every one of these things that she does, and she says, email, bad, And she says, why am I saying that? Well, because, you walk down the hall, and once you create that record, and no one knows the tone, and anyway. So in this instance, he says, let's see, I'll have to clean it up, but you'll get the idea. Carl, so who lit a fire under this? It is a negative word that begins with the letter A. If he's involved in litigation, ongoing, and or other projects that he hasn't asked about, can I shut him down? So the response isn't, yes, I'm in charge of FOI, I'll take care of it, it's he's a, how do I get rid of it? Well, the guy's a journalist. It goes right up on his blog, it goes right up on the public TV thing that he does, and then he's connected. It's in the Current the next day with, the asterisks and stuff. Records requests are called, and it's on FSB with the bleeps and the whole thing. Very bad for the city of Hartford, very bad. So the Corporation Council tries to, but he can't do it. He hates this guy so much he can't do it. In his letter of apology, apparently you have little else to do other than to pester me in this office and other city departments. Recall that I do not work for you. The purpose of the FOIA statute is not to provide you a playground. Folks, even if you think it, please don't write it. Because now there you are again, and it's plastered all over it. I mean, nothing is accomplished by taking that tack. P.S. He doesn't give them the records because he doesn't like them. None of them are exempt. The guy files a complaint, Hartford loses at FOI commission again. There's nothing to be gained by going down that road, even if it's somebody who's difficult. You look at the records. You have a right to look at the records. Are they exempt? Are they not exempt? Do we give them out? Ignore, the people expect this. You asked the question earlier, Cheryl, about, what if it's something you don't have or what? Nothing stops, you get a request and you don't get it, or you're not sure where they're going with it. Nothing stops you from reaching out. In fact, I would always encourage you to reach out if you're at all uncertain, or if it's a large request and you want to try to get them to narrow the scope of the request. We have sessions where we go on and on, we do some role playing. People expect this. Unfortunately, even after 39 years, people expect this, but if you reach out to them and say, look, I'll give you all this stuff, it's going to take 6 years to get it, but if we can find out what you're trying to want to learn, narrow the scope, work with them, people are like, wow, they're actually trying to help. You'll be surprised how often it works. Yeah.
A real quick question. A while back, we had, at another school district, we had a new union come in, and they were trying to get out of a defined benefit plan, and they started making requests that were very, very labor intensive and somewhat frivolous. But all the data was gathered and names deducted and all the work that had to get done. What's the policy on charging for the labor if you have a really skeleton crew of people working around the clock, because this had to do with negotiations.
Okay.
So everybody had to stop what they were doing and,
You will appreciate some of the answer, the other part you won't. There's no charge for labor. There's just no way to charge for labor. But the next thing we talk about after we talk about that 4-day response is that a request for records under FOI never means drop everything and do it. It never means you put aside all the other work you're doing because an FOI request has come in. Yes, it's important. Access is important. We wouldn't be here doing this if it wasn't. But the law says you must provide access to these records promptly.
but if you're going to arbitration
Well,
and you're at,
but then some of that was for you too then, some of the
well,
records.
I mean, ultimately,
Yeah.
we ended up giving it to,
Some of it was for
Our
your
law
own
firm.
purposes. But let's suppose it's a request not related to a union, and it's enormous, and you can't narrow the scope, you can't get the requester to think reasonably. Then you say, okay, we are responsible for prompt access to these records. That's what the law, prompt access. Does anybody want to take a shot at what that means? Well, nobody really knew when the law was written. It says promptly. So the matter goes to court, and the court says, we got you on this one. Promptly means without undue delay. What does that mean? What does that mean? Well, I'm a former journalist. I kind of like a deadline, an hour, a day, a week, a month, whatever it is. You don't have that. That's the bad news. The good news is it allows you to interpret how long it's going to take. And if it's budget season, it might take longer. If it's the middle of the summer, it might take less time. You look at the depth, the scope of the request and say, okay, you're asking for this without pulling people off of other jobs, without bringing everything down, without stopping all the wheels of progress. This is how long it's going to take. Now, again, as I said in the beginning, the other person's gonna interpret too, the requester's gonna, so you wanna be reasonable, you wanna be prompt, you wanna deliver without undue delay, but not at the expense of everything else you have to do. I can't stress that enough. You do not need to create a record that doesn't exist. Many times people will be asked for lists and for charts and for things that you just don't have. They may think you have them, they may think you should have them. And if you should have them, that's somebody else's problem, it's not an FOI issue. I don't mean to be flip, but we can't do it. If you don't have a record, we cannot make you create it. And hand in hand with that goes the idea that you don't necessarily have to do research. Now, the line between what's searching and researching often gets blurred. You know, to me, it was always research if I had to go through a huge box and find stuff, but the courts have said, even if you do, that may feel like research, but if the record's actually right in front of you, and you're just looking for it and it's clearly marked, that's just searching. It's not researching. Researching really has to do more with trying to figure out what's being asked for. What, you know, does that belong in this request and the response or not? That's really what that's all about. Yes?
It's easy to have a paid employee to demand that they comply with an FOI request, but what if a specific board member will not comply with a FOI request, even though the chair has requested that?
The board member would ultimately be the target of a complaint if one's
So
filed.
would the reply just to?
Right, let's suppose a request comes in for some documents that, how many of you are there, 9 of you? That of all 9 board members, and 8 turn them in and 1 doesn't. The complaint would be unfortunately against the Board of Ed, but just because it's part of the body, but the individual would be targeted, because the other 8 have turned everything in and the one hasn't done it.